And welcome to today's webinar. This is the fourth webinar in Polis's 2012-2013 webinar series. We'll have one more happening in June, and then we'll take a break and be back in the fall. I'm happy that you all could join us here today. My name is Laura Brandis, for those of you who don't know me, and I'm the Communications Director at the Polis Water Sustainability Project, which is located at the University of Victoria. At today's webinar, our guest speakers will be discussing some of the contemporary issues surrounding water rights or water entitlements and how they play into situations of problem-solving water scarcity. Parts of today's talk draw on a discussion paper that was co-published last June by Polis and the Environmental Law Center at the University of Victoria. And for those of you who are interested, I will make that paper available at the end of the webinar today. Before I get into introducing the speakers, I want to take a moment to say thank you to all of our webinar partners and sponsors who helped make this series a reality. So you can see all of their logos and names there. For this specific webinar, I want to say thank you to the University of Victoria's Environmental Law Center and Faculty of Law, as well as PCFFA, and as well our funding supporters and our series partners. So for those of you who've attended our webinars before, you'll know there are always a few housekeeping items that I like to go through right at the beginning. The first thing is audio. You will have all noticed that your lines are muted, and the reason for that is to avoid background noise and audio chaos. If for some reason you are unmuted, please press *6 and that will mute your line again. So myself and the two speakers are the only ones that can speak. So this brings me to point 2, which is the question period. Since your lines are all muted, the way that we'll handle questions is through the chat box, which a number of you are using already. In the bottom right-hand corner of your screen, we'll handle questions at the end after both presentations. You can type any questions or comments in there. I'll read them out and facilitate, and both of our speakers will be on the line as panelists to answer any questions you have. And the third thing is introductions. You might as well use that chat box right now. And I always like to get a sense of the community that we have in the webinar room today. So if you want to just let me know who you are, what organization you're with, and also how many people are listening on your end, if it's just you or if you have a group. And as you do that, I will introduce today's speakers. So the first person you'll hear from today is Deborah Curran. She's the Hakai Professor in Environmental Law and Sustainability at the University of Victoria Faculty of Law. Her research and teaching focuses on the allocation of environmental entitlements and property interests in law, which are things like land, water, and rights to those, in the context of healthy ecosystems and colonial and indigenous systems of law. Deborah's work is initiated by community members, and she works with them in a variety of contexts, including through the Environmental Law Clinic, a unique field course that she teaches in environmental law and sustainability, which is held at the Hakai Beach Research Institute on Calvert Island up the coast of BC. She also works through us at the Polis Water Sustainability Project and with local governments across the province. As a municipal lawyer who focuses on sustainability issues, Deborah is currently writing on green real estate, local governments, and the evolution of water law in Canada. Glen Spain is our second speaker here today, and he's the Northwest Regional Director and General Legal Counsel for the Pacific Coast Federation of Fishermen's Associations, which is also known as the PCFFA. And this is the U.S. West Coast's largest organization of commercial fishing families, and he also works for its Institute for Fisheries Resources. This is an affiliate marine research and fisheries restoration and protection organization. Glen has been working on salmon restoration and watershed protection issues in the Klamath Basin, and really also in much of the U.S. West Coast since 1982. He was PCFFA's lead negotiator in the Klamath settlement process, which he will be discussing later this morning. And after nearly 10 years of hard bargaining, this process resulted in the current 2 Klamath settlement agreements, which were signed in February of 2010. So at this point, I'm going to ask Deb to bring her voice on the line if she is muted, and you can just take it away, Deb. So I cannot hear you, Deb. You may need to press *6.
There, am I now coming through loud and clear?
You are coming through, yes. Take it away.
Thanks so much, Laura, for that kind introduction, and thanks everyone for participating today. Glen and I have been in discussion over the last year or so as I've been thinking about and working on water law issues across Canada, particularly through our Water Act modernization process here in British Columbia, at least thinking about the Water Act modernization, where for the first time we're taking a very comprehensive look at modernizing our Water Act. And the staff in the Ministry of Environment have been doing a wonderful job of not only stimulating a conversation here in British Columbia, but also seeking a lot of diverse opinions on how it is we take an act that was largely created in 1909 and turn it into something that's much more responsive and reflective of a modern day approach to managing water here in BC. And as we are thinking about that and having this conversation, it strikes me that the same conversation has been had certainly across North America in different jurisdictions and at different scales, whether it be in Oregon as water entitlements are used as an excuse not to provide water for fish, or in Ontario as a part of the conversation about drinking water protection. And my interest then becomes in looking at how is it that we take a water management regime that is really based on very long-standing and well-understood water, what I call water entitlements. Many people would call them water rights. And how do we morph that, or how do we adapt that in this age of changing environmental conditions, changing ecology, particularly at a local level? So what I hope to do today is just set the stage for what Glen is then going to provide you with, a very specific example, how one regional community or basin community has had that conversation, gone to a very low place of spending millions and millions of dollars on litigation before they kind of came out of that awful, conflicted place to somewhere where the major water users and water interests came to an agreement about how it was they were going to manage water together. And really the takeaway is that past legal arrangements and being stuck on our existing water entitlements, given our changing environment, is not going to get us to where we need to be in terms of sustainability for our communities. And when I say sustainability, I don't just mean environmental sustainability. I certainly mean economic sustainability and social sustainability as well. So what I'd like to do is, these two quotes really capture very well sort of the heart of what it is we're going to be talking about today, talking about how institutional arrangements really limit, past institutional arrangements limit what we can do in terms of water management over time. And from a very specific legal perspective that I come from, often we are always looking to solidify entitlements or rights as a form of property, whether that be to land, to water, or to natural resources. And that notion of property and the way in which we conceive of it as colonial governments really is fundamentally opposed to adaptive management, which is what we understand from resource management and scientific, the evolution of that kind of thinking, that we need to certainly get to a place of adaptive management. So what I'd like to do very briefly in the next 15 minutes before I turn it over to Glen to give us a very specific example of perhaps a modern approach to the way in which we adapt water entitlements, I just very quickly like to set out a few problems with, in particular in Western water law, legal entitlements to water, and this will be familiar to most of you on the call, but I'll just set it out specifically in the context of this conversation today. Then I wanted to talk, or just briefly touch on, two specific aspects of the way in which governments manage water and water users actually use their entitlement, to show that what we have on paper and in the law is not necessarily what's going to happen on the ground. And then that leads me into my third point, law reform. What does that behavior then tell us about what we should be looking for or aiming for with our law reform over time? So turning to the first point, very briefly, legal entitlements to water. As many of you know, in particular in Western water law, so when I say Western water law, in Canada I mean the prairies and British Columbia, and certainly in the United States, all of the Western states are based on similar principles, although somewhat different in each state, but very much based on similar principles. The first one being, and the one for our purposes is perhaps the most important, is that the most senior users, those who either used it first, used the water first, or have obtained their licenses first, have priority over all other uses. So as one's economy changes and ecosystem conditions change, it's still that most senior user who's using it for a specific purpose. So it might be that the most senior user in a region has a particular allocation of water for agriculture, for example. They take priority over all other users. So irrespective of ecosystem conditions and irrespective of the value of that use over time or what it brings into a regional economy. So this is a very fixed entitlement, although we're going to more time-limited entitlements now in British Columbia under our licensing regime, but the majority of licenses are in perpetuity. They go on forever, and they're also fixed for a specific use and tied to a particular piece of land and the use of water on that land. The final thing that I wanted to mention is that licensees are required to use their water, or after 3 years there's the potential to lose the ability to use it or to lose that entitlement. So that this creates, in law, there is an incentive to use the water, which we can certainly understand from an efficiency perspective, in that we want to make sure that people are using the water that they have under license. But from a conservation perspective and an adaptation perspective, it doesn't promote conservation in a very good way. So these fixed allocations really are a particular historic artifact in time that haven't been played with very much in law. So we consider that our Water Act in particular in BC is over 100 years old, but we're still basing it on these kinds of principles that really were established back in the early 1900s to promote settlement, promote agriculture and industry, and to provide certainty of investment. Now, this particular way of doing things really is challenged, in my opinion, in three ways. The first is that layered on top or underneath these entitlements as a burden on Crown allocation are Aboriginal water rights and arguably title to water. And the first time we've seen this conversation happen in British Columbia and in a meaningful way, in terms of actually talking about what that might mean, is the Halalt First Nation in BC case of a few years ago. The quote that I have there in front of you is what the judge said about the actual interest that the Halalt may have. This statement was played down by the Court of Appeal because the case was not actually to determine rights or title. It was a judicial review of an environmental assessment certificate. So we have to read these with some caution. It certainly is not a statement about what the Halalt actually have. But it's interesting to note that in that case, the court went through extensive detail about who owns water under reserves and the application of what we understand to be sort of Aboriginal rights and title jurisprudence. Usually in talking about land, this was talking about water. So we certainly have this notion of there is a very strong proprietary interest that warrants consideration, given our existing water licensing regimes don't consider Aboriginal rights and title at all. The second thing that really will and really is becoming much more important is this concept of adaptive management. And I'm just going to go through a few slides that give us the context and the need for an adaptive approach to water management rather than a fixed entitlement as we have now under our licenses. So as you all know, one of the figures is that we use 326 liters per person per day in Canada. Over 80% of that is for toilet, bathing, and laundry. So this is indoor use. It takes about 100 liters for a 5-minute shower, about half of that for using a shower, water-efficient shower head, and about 1,000 liters to produce a kilogram of potatoes. Globally, in terms of water use, almost 70% is used for agriculture, 23% for industry, and 8% for municipal. We only use about 3% of treated municipal water for drinking. So the rest of that is used for agriculture, outdoor uses, and other things. In British Columbia specifically, to give some BC context, we have about 43,000 licenses on 17,000 surface water sources. So if you think of those, the majority of those are fixed allocations. That's a lot of entitlement out there in the world at this point in time. And groundwater is not regulated in British Columbia at this point in time. We have about 291,000 watersheds and sub-watersheds in BC. And we have a very high concentration of land and water uses on a very small percentage of our landscape. So on only 2% of the landscape from the southern Okanagan to the Fraser Valley to southern Vancouver Island, 80% of the population lives, and 80% of our farm gate receipts are generated on that landscape. So what that means is you have arguably your highest water usages on only 2% of the landscape in British Columbia. In certain regions like the Okanagan, we're already experiencing over-allocation. So there are 235 of 300 streams in the Okanagan are fully allocated. And in that same landscape, 30% of the endangered species in British Columbia live. The final sort of set of figures are around the amount of irrigated land that we're going to need to feed ourselves over the next 25 years. So the BC Food Self-Reliance Report a few years ago talked about us needing a 50% increase in irrigated land here in BC in order to feed ourselves. And finally, we've seen an 80% increase in withdrawal of fresh water in Canada between 1972 and 1991, and during that time there was only a 3% increase in the population. So as you can see, these figures really point towards a need for adaptive management, in particular because we're dealing with the context of climate change. And so this kind of adaptive management, specifically in a regional or watershed context, really causes us to think about the way in which our water licensing and allocation as fixed entitlements can adapt over time. And we haven't done that from a sort of province-wide legal perspective yet in terms of the Water Act, although arguably, certainly there are tools within the Water Act where a staffer, a government staffer, can make an order that would look to adaptation. The final thing I wanted to mention before going on to failure of legal entitlements is to just talk about this notion of regulation versus compensation. So we often, when we get to the point of talking about adapting water entitlements, usually people say, well, you'll just have to buy back those entitlements. And I would argue that we actually can regulate the way in which those entitlements are used to a much more sophisticated degree than we do already. And if we turn our minds to thinking about the regulation of land, for example, so local governments create zoning, they regulate the way in which we can use land, and tell us what we can and cannot do with the land. By virtue of that regulation, we don't have to, the local government doesn't have to pay us compensation as landowners. That's simply a part of living in an urbanized environment usually. So too should we think of water entitlements in the same way. They are, if you would argue they're a property right, they are certainly less than a property right that we would look, that we would ascribe to land, which is perhaps our sort of our biggest property right or our most firm property right. So if we think of a right to use water as a use right, certainly we can regulate it to a much higher degree in the way in which we use those entitlements, short of compensation, before we have to compensate people. So those three factors, Aboriginal rights and title, the need for adaptation, and this tension between regulation versus compensation, are three issues or aspects of our modern water management and regulation that are, in my opinion, challenging very significantly this fixed entitlement regime that we have adopted historically and are now trying to move forward and address. So then what do we do with this? How is it then within this fixed entitlement regime and the way in which law gives out or allows people to use water, how is that system working, and how does it then give us pause to think if we're moving forward with Water Act reform and looking at entitlements? Well, there are two, it strikes me that this might be part of our larger conversation when we get to question period, but I'm just going to throw out two things that I invite you to take issue with. But in a lot of the commentary, and certainly in a lot of the court cases and the Environmental Assessment Board hearings that we're seeing now certainly in the last 5 years, and in particular in the last 2 years, there are two particular characteristics, I guess, of our water management regime that show that it's not working quite as it's supposed to. The first is that the state does not, as in the Crown, the provincial government does not have the resources to really make the water entitlement system work. It is not, there simply are not enough staff on the ground to respond adequately and quickly enough to watershed scale and sub-watershed scale shortages and behavior of the parties in terms of who's taking what water and when. Now, they certainly have the tools to do that. They can make orders and require people to behave in certain ways and change their licensing behavior on the short term. But it doesn't happen necessarily in the timely manner that is needed. The second point is that although we have this firm and fundamental legal principle that the most senior water entitlement holder is the one who gets to use the water until the last drop is up, although there are Federal Fisheries Act problems with that, but they are allowed to use the water and everybody else has to stop using water before they do. In fact, the behavior of water users when they know each other in a sub-basin is that until a certain point, they generally try to cooperate. And the cooperation is, you can find this in a variety of other ways in which people behave as neighbors, but the response of licensees to water shortages tends to be to share the pain to a certain extent or share the shortage in recognition that an economy and a community can't really withstand the sequential cessation of water use in times of shortage. So we see this not only in British Columbia, but we see this in water adjudication processes in the southern United States, in court processes, in multi-party negotiations in the over-allocated states of Oregon and California. And ultimately, at the end of the day, what we see are usually negotiated settlements where people are not necessarily relying on their legal entitlement. What they're trying to do is get to an agreement of how to use water over time and assess how people are going to use water in times of shortages so that their economy can keep functioning. And this is where the Klamath Basin agreements come in, and I'll turn it over to Glen in a minute to give us some more detail about that. There are other examples of this as well, so you could look to the Lower Athabasca Water Management Agreement, the Umatilla Basin Salmon Recovery Project. There's a variety of ones where users are sitting down to try and figure out in an era of adaptation or when adaptation is needed because of changing hydrology and ecosystem hydrology, they are sitting down together to figure out how is it going to work over the long term. Just before I go into my final point about Water Act modernization and the thoughts moving forward, I just wanted to draw your attention to a couple of Environmental Assessment Board cases or decisions that really get at this notion of the state does not have the resources to make the water entitlement system work. So one is the Fulford Creek Holdings and Gauthier versus Ministry of Environment. It was a 2011 Environmental Appeal Board decision where it was 5 years between a beneficial use declaration that showed misuse of water in a fully allocated watershed on Salt Spring Island and enforcement action by the Ministry of Environment. So a 5-year gap in that enforcement. The next one is Sanders in BC. It's a 2011 Environmental Appeal Board decision, and the board in that case mentions budget constraints and criticizes a lack of staff expertise and data in evaluating applications for water licenses. And finally, a 2012 decision called Helmer and British Columbia. The language used in this license appeal decision points towards the need for cooperative effort between water users and license holders on the same water source or in the reaches of the same stream. So explicitly, not only the evidence given by Ministry of Environment staff, but also the Environmental Appeal Board talk about the need for cooperation and for working together. All right, finally then, turning to the Water Act modernization or law reform here in BC, I just wanted to mention in closing how the Water Act modernization process is responding to these concerns that I've laid out today, and also to conclude with some thoughts about local water planning and governance. So many of you will know that our Water Act modernization priorities here in British Columbia are as set out on the screen. So the first one is to protect stream health and the aquatic environment, introduce flexibility and efficiency into the water allocation system, regulate groundwater, and to improve water governance. So this provides a great opportunity in looking at these very important and explicit priorities to take into account this need for adaptation within the water governance system. And then as we're moving to Water Act modernization, that means being able to experiment with place-specific governance regimes or broad-based local initiatives. So really what the Water Act modernization, given what we know about fixed legal entitlements and the actual response of water users in, you could argue, jurisdictions across Western North America, the way in which they're moving to place-based negotiated arrangements rather than relying on fixed legal entitlements, really gives a lot of evidence to the provincial government when they're doing Water Act reform to allow more localized coming together for collaborative agreements around water management. So with that, I will turn it over to Glen to give us an example of a very complex and I would argue sophisticated place-based water management agreement that comes with a lot of baggage, and then in moving forward is a very interesting example for all of us in Canada to watch and to look at as a collaborative water management approach. Thank you.
Okay, let me try and see if I can manipulate this. Okay, there we go. My name's Glen Spain. As you know, we've been involved in the climate negotiations for some years. I am not a water lawyer. I'm always aware of the old saying in the legal profession, water law is to law as military music is to music. Water law is a Byzantine network of 51 different jurisdictions, actually, in the United States. It's state-based. There is no such thing as federal water law, but there are federal environmental statutes that do impact water law in the various states. Looking at the Klamath Basin, you'll see instantly a few of the problems that are endemic to water law, particularly across state and political lines. I get invited to these seminars because the Klamath is a perfect example of what never to do again. and we do have a lot of, hopefully, lessons that we've learned rather the hard way that perhaps could guide some other jurisdictions to avoid some of the biggest pitfalls. Looking at the Klamath Basin, it's a huge basin. It is larger than several U.S. states combined, approximately the size of New England. It crosses state lines. It's roughly bisected with 2/3 of the basin in California, a third in Oregon. That instantly creates some problems because the jurisdictions of water law are different and the rules are different. Oregon, for instance, has certain doctrines that they apply, such as connecting groundwater to stream flows. California does not. California is also one of the very few states, perhaps now the only state, that does not control groundwater as a matter of state water law, but it leaves it up to local counties. There are also very primitive statutes in California in terms of in-stream water rights. That is, rights for fish and wildlife are not recognized for the most part under California law. They are in Oregon, but you always get the most junior water right. So those rights are particularly meaningless. If you look at the basin, some of the various stakeholder interests, of course, are the tribal governments in the upper basin, the Klamath tribes of Oregon, who've been there forever. In their mythology, literally forever. You have lower basin tribes, the Karuk, Yurok, and Hupa tribes. They've been in their lands for a long time. There are conflicts built in between upper and lower basin water needs. Right in the middle of it is the Klamath Hydroelectric Project, which has a water right for the use of water for hydropower generation. The upstream irrigators have taken about 300,000 acre-feet of water for various ranches and farms, subject to Oregon water law. In the middle are is the Klamath Irrigation Project, which is a giant federal irrigation project. It uses about 400 to 450,000 acre-feet of water. And tied to it is the National Wildlife Refuge, which is one of the very few wildlife refuges that has no meaningful water right in our refuge system, because its water right is junior to all other water rights above it, including the Klamath Irrigation Project. So we have a situation where much of the water is taken out of the river before it even crosses the border into California. And in fact, under Oregon water law in 1908, the Bureau of Reclamation Irrigation Project was allowed to have, quote, all the water available and unappropriated to that date, unquote. So they have literally the right to dewater the river at the state line. This doesn't sit very well with California because its water statutes depend on there being water. The downriver tribes, the Karuk, Yurok, and Hupa tribe, have water rights of their own by treaty or federal law. All the interests in the middle have water rights. There's a lot of federal land there, and the federal land claims water rights under various state laws. And then, of course, our organization is a commercial fishing association. We depend on the river for healthy salmon runs, and those salmon runs, when they hit the estuary, go both north and south and are a major component of the salmon fishery throughout much of the west coast in the U.S. So these are all the interests that had to come together and were in deep conflict. The basin itself is grossly over-appropriated. There were three giveaways of water rights. The first giveaway was theoretically to the tribes who, by treaty dating back to prior to statehood, were guaranteed sufficient water for their customary fisheries and their customary uses. That was, for the most part, ignored. Then the second water giveaway was to the irrigation system. They basically got a large portion of the water, but their water availability was determined without consideration of the water needs of the tribes. And then under modern environmental law, you have the Endangered Species Act and you have the Clean Water Act to try to guarantee water quality in the U.S. That is another allocation of water for fish and wildlife needs, but that was essentially last in time. So if you use the typical allocation, first in time, first in right, fish and wildlife needs and federal environmental laws come in and at the very last of the line. If you look at the basin itself, there's an incredible diversity here. It's a very unique basin. It is a pre-ice age ecosystem. The ice sheets didn't come down quite that far. They did isolate that area. As a result, many of the species evolved separately, and there are many, many species in the basin that exist nowhere else on Earth. Incredible rich diversity, including the salmon runs, which go all the way up to the top of the basin originally, and many other species as well. There's also an overlay of human settlement, European settlement. You have agriculture. It's one of the more productive agricultural areas in the region. You have mining with a legacy of mining problems in river systems, including mercury. You have dams for hydropower and some for irrigation. You have all this overlaid on the native Aboriginal tribes and the First Nations there. You have logging over much of the area, much of it overlogged. And of course you have fisheries dependent on the salmon coming from the river. All of those are economic stakeholders in some fashion. Now the Klamath Reclamation Project, it's over 100 years old, some 200,000 acres, many family farms, and these are not big agribusiness operations, they're small towns, small family farms. A whole network of water delivery that takes water from the upper Klamath Lake through the Klamath River, moves it around all sorts of places in a giant sort of Rube Goldberg irrigation system. It picks up pollutants at every stage of that process, and then it is poured back into the Klamath. So you have irrigation and water quality problems, as well as simply use of a large portion of the flow of the river. Now the river flows well. It's in the millions of acre feet, but not during the summer. It's a very arid area. It is high desert. It's essentially the rainfall there is equivalent to what you would find in any desert, about 10 to 12 inches a year. Not a lot. And it depends heavily on snowpack in the surrounding mountains. But the end result of the irrigation project is a great deal of the water is taken out in the upper part of the spigot. In addition, you have the dams. Now, a lot of the negotiations were concerning dam removal. The dams are important in terms of water quality. They jeopardize water quality in a variety of ways, slowing down natural river systems, inundating cold water pools, and particularly blocking salmon runs that once migrated into the topmost portions of the basin. The historic distribution was all through the upper basin, and the dams essentially cut that in half. But the dams are only one of the impacts. Of course, the big problem is water over-allocation with no thought to tribes or ecosystems. The irrigation project itself also is, in dry years, becomes heavily groundwater dependent. By pumping groundwater, you're actually minimizing some inflow from nearby streams to the local river, so you're basically doing two bad things simultaneously. You're depleting an aquifer, which takes a long time to recharge, and you're depleting local flows to the river, so that is another problem. The other problem is that federal law has been deemed to preempt state water rights. That is, the environmental laws like the Endangered Species Act to some degree, the Clean Water Act, and also tribal treaty rights, which are federally recognized rights under the U.S. Constitution. Those also have an overlay and can reach down into the water rights system and change things. The big problem in the basin is it was never adjudicated. We're now at the tail end of a 37-year water adjudication process. Whole careers have been made on doing nothing but water rights claims. in the basin. And, people have grown old, died, and retired before there's even a decision. That decision is pending now. So some of the recent history of the basin has been a history of conflict over water. In 2001, because of the preemptive effects for the first time of the Endangered Species Act, a lot of the irrigation system was dewatered. A lot of people suffered economic loss. In 2002, they decided to appease the political interest that essentially rioted in the streets in Klamath Falls over water and restore full water to the irrigation system, but at the expense of the lower river fish. So we had the U.S.'s worst adult fish kill in the lower river, essentially wiping out a whole generation of salmon. That really activated people in the lower river, including the tribes and commercial fishermen. And in 2006, as a result of that loss in 2002, we had a major commercial fishing shutdown that shut down about 700, 800 miles of coastline and caused an economic disaster for many coastal communities, which we're still reeling from. And in the midst of all this was water adjudication. There's an old saying by Mark Twain, whiskey's for drinking and water's for fighting over. Well, we do a lot of that for sure in the upper basin. With an unadjudicated system, it means that the state agencies are helpless to enforce water rights because there's no clear water rights system where there are delineated water rights. There are many conflicts and they can't take sides, so that's one of the biggest problems in the basin. All of this resulted in multiple lawsuits, multiple political forces trying to undo this law or undo that law in the U.S. Congress, all to no avail. The court systems basically weren't going to create any more water. So what happened is that under court order and under the necessity of dealing with these back-to-back rotating crises, each community suffering in its turn in the basin, people started working together to see if we could work out a better future, a more certain future. What we basically started doing is, with the excuse of dam removal pending, that is a dam relicensing, the 50-year license that is given for these dams was up, we coupled that with major water reforms and reallocations. Both water quality and water quantity are affected by the dams to some degree. And all of this got blended together in 10 years of tough negotiations, multiple lawsuits, lots of political posturing, believe me. But it resulted in 2 Klamath settlement agreements signed in February 2010. One to work toward dam removal, but the most important, to work toward major reallocation and reforms of a badly over-appropriated water system. Now, the real question is, what will it take for farmers to voluntarily give up water? Because that's really the bottom line. They were taking too much water for the system to sustain itself. So we started talking across our usual dividing lines, staring at each other across tables in court, and people started talking. We found that what the irrigators needed most was more water security, and they could live with less water if they had more water security. They needed affordable power so that they could pump that water from place to place. This is an irrigation-heavy system. It costs money to move that water from place to place. They were terrified of the Endangered Species Act's preemptive power, and they needed some sort of way of working around the Endangered Species Act, doing good restoration work, but not being penalized for when that happened. So with that in mind, we started working out a deal where there would be a cap on future irrigation diversions to bring it back into sustainability, but providing greater water certainty for the farmers. This is money in the bank for them. If they don't have, however much water they are promised, if they can't be assured of delivery, they can't go to the bank and get a crop loan They can't finance a new tractor, a new combine. They can't do any of the many things that farmers are heavily dependent on in terms of financing. So it's something they can live with less water, provided they have more certainty of what they actually get. We provided for compliance with the Endangered Species Act in ways that would also help key salmon runs. We're working together with them to provide low-cost power, reasonably low-cost power, and also, in particular, the festering water dispute with the Klamath tribes who claim the senior right was resolved by these agreements in an amicable way that guaranteed the tribe something and guaranteed the irrigators the right to continue in operation. The essence of it is this chart. If you look at the little round dots, those are actual historic deliveries through that period of time, 1961 through 2000. What we agreed is that in the future, the limit would be that line for irrigation deliveries to the irrigation project. One of the characteristics of that line is the drier the year, that is the less rainfall, the more water they would use on their fields, thus exacerbating all of the impacts of drought on the lower river and the fisheries. The end result is that would be brought down to this level, and that would generate an additional 100,000 acre-feet at least for the lower river. In addition, there would be a contribution from off-project irrigators as well, and there would be about another 100,000 acre-feet in additional storage. It's a storage poor system. We have a fair bit of rainfall in the winter, but we can't store that and keep it over with more storage. Working together, we've got a common ground there. So the other thing is, if you look at the problems of compromise, the irrigators would have to give up some water, but they would get much more economic stability too. This is about a $750 million a year, that's US million, economic powerhouse when it's all running properly and it all has proper water supplies. These economies are major employers of that region. But because of the back-to-back disasters, 2001, 2002, 2006, 2010, a large amount of federal money was needed to actually spend on disaster assistance to patch the problem up, but never resolve it. The good selling point for the Klamath Basin Restoration Agreement, the restoration and water allocation component of the settlement, is that in the long run, it's cheaper to fix the problem and to invest federal money to fix it to avoid those disasters in the future and the economic cost of each one. And in terms of the restoration funding, it's not a lot compared to how much money generally goes to these kinds of programs. So there you have basically how we managed to piece together an agreement. The dams would be removed in a way that would be actually cost effective. Dams cost money, replacing them costs money. When it costs less to replace them than to keep them, you have the attention of the company and their support, and that's essentially what we worked out. A reliable water supply for family farms and ranches. That includes some restrictions on future groundwater tapping so that we are not depleting the aquifer and thus depleting the springs that feed local rivers. So we actually have within that agreement a fairly stringent by-state working arrangement to minimize groundwater impacts and aquifer drawdown. A lot of jobs would be created in this process, and essentially ending the water wars helps stabilize the economy of the whole region, and that's all to the good. Ultimately, besides several U.S. Federal agencies signed on, the states of California and Oregon signed on, 3 of the 5 major tribes in the basin signed on, the company that owns the dams, several counties, many irrigation organizations, several irrigation districts. They're all quasi-governmental entities, independent entities, and so they had to sign on as well. and a multitude of non-governmental organizations, including our own. So where we are on this is, well, we've solved the problem, except that components of it require congressional authorization. And as you probably know from reading headlines, the U.S. Congress is in a state of permanent gridlock and has been for several years. So we're doing our best to get that moving. That's where things are the sticking point right now. But we are working collectively as stakeholders in that system to try to implement as much of it as possible with whatever alternatives we've got, whatever funding we already have in the basin. There is considerable funding there already, and with whatever legal authorities are available for restoration work. If you want more information about it, all the documents, which are, you probably need a native guide to walk through the documents themselves, but they're very comprehensive, and they leave a lot of details out there plain for people to see. They include a number of water reforms across state lines, and that's an important element. But it's a contractual relationship. It doesn't supersede law. So we still have this overlay of water allocation problems, but we do have the agency's cooperation as signatories to try to reform that over time. And this is always one of my great thoughts. All of us are neighbors along this river, and that made a big difference ultimately. We're all tied together. Whatever happens in the upper basin affects the lower, and vice versa. Ultimately, we all have to share this resource. What we are trying to do, which is very unusual, is rather than fight over water, try to bring the water supply into line with water demand, so we don't demand or require more than is actually available. And in that availability calculation, that means how much for fish and wildlife, how much for tribal treaty obligations, how much for agriculture, and how we do that in a precautionary way and using adaptive management. We do have an overlay of climate problems. We are seeing diminishing snowpacks. We are seeing a greater incidence of droughts. So one of the key elements is a drought plan for how we, in advance, agree to share the pain among these various stakeholders. And this year is a declared drought as of last week. So we may be put to the hardest of tests, the test of real-world realities. So we'll see how that goes from there. And I'd love to entertain any questions.
Great. Thanks so much, Glenn. I'm sure that the questions will start pouring in shortly. So as I said at the beginning, if you just want to use the chat box, Deb, if you're muted, if you want to bring your voice on the line, and both Deborah and Glenn will be available to answer any of those questions. As you guys are typing, I did have a couple of files that you may be interested in. These were available on our website where all the webinar information was posted, so some of you may have seen these. These two files are PDFs, and one is a discussion paper, and one is a summary of a workshop that Deborah was involved with on this topic. And I have a few web links here, and I'll add the other ones that that Glenn just posted as well. So you can just, if you want, go to them directly from here.
I should just say that the original quote, or one of the original quotes that I started off with, the one that said, adaptive management is inconsistent with the fundamental urge for stability that underlies property law. This was one of the concluding statements by Holly Doremus and Dan Tarlock, two law professors who wrote the book Water War in the Klamath Basin. So looking, I think it came out several years ago, so it's not sort of, it certainly ended when the agreements were signed, but it doesn't have a lot of the implementation aspect of it that Glen is more aware of. But certainly that was their conclusion in looking at the behavior of everybody in the long history of certainly the last 20 years in particular of all the legal wranglings. That was one of their conclusions.
Great. Thanks, Deb.
I see a couple of questions there. I assume, by the way, Laura, that you'll provide PDFs of the two presentation slides.
Yeah, so after the webinar, we are recording the webinar, so I'll be posting that. I can post a PDF file of the full slides as well, and we'll be posting a webinar summary as well.
Let me answer the one question in terms of the various tribal interests.
Yeah, so Glen, if you don't mind, I'll just read them out just in case some people don't have access to the computer, or just means that everybody's on the same page. So the next question here from Tyler Palov. 3 of 5 tribes signed on to the Klamath Agreement, wondering why the other 2 did not. So Glen, take it away.
The other 2 federally recognized tribes, the Rezagini is a very small tribe in the very lower part of the river. They weren't really involved in it for various reasons, and the other tribes really didn't want them to be involved in it. So they essentially rejected the settlement. But there are only, I think, something like fewer than 100 members of that tribe. The other large tribe, which is the Hoopa Valley tribe, is not actually on the main stem river. They're on a major tributary, so they are not affected by most of the water issues that affect the main stem. So their interest was somewhat separate. They have some problems with some of the numbers. They don't believe the numbers are enough water, so they were in opposition. That is enough water for salmon fisheries. And their fear is that it will somehow jeopardize their tribal water rights, which is not the case. And many experts on that have looked at that and said that's not the case. The other major opponents, which I should mention, the other opposition is, again, and some of the people in the upper basin don't want to give up any water. They think things are fine. And there are some folks in the middle, including Siskiyou County, who doesn't want the dams down. They think the dams should remain. They even had a vote of the citizens there whether to keep or allow the dams to be removed. They voted 79% to retain the dams. The vote, however, is meaningless because they don't own the dams. They're private property, and the company is not obligated to go broke running dams that are no longer cost effective. So ultimately, that was a meaningless gesture, but there is a lot of political resistance to the whole concept of dam removal without a lot of thought about whether dams are good or bad, whether they serve their function, whether they're economically viable, etc. Those are considerations that the company does have to deal with.
Okay. The next question is coming from Manitoba Conservation and Water Stewardship, asking, when issuing Water Act license, do you consider Environment Act licensing?
I'm not sure whether that's aimed to me or to Deb. In U.S. law, there is no federal water law. It's left to the states. And that means you've got 50 different, sometimes incompatible systems of water law. And when you have a basin that crosses state lines like we've got, you've got serious conflicts. And those cannot really be resolved in federal law. The only way we can resolve that is by getting interest in the basin on both sides of that state line to try to work out some sort of deal, and that's what we've tried to do here.
I see that the Ministry of Environment Victoria is typing. It strikes me that they and the 5 of them sitting around the computer are going to answer that question. So I will only throw in that that the regional or assistant comptroller has a lot of discretion when they are approving licenses to consider a variety of factors. And although stream flow is not, or environmental flows are not in the Act or the regulations, under the water regulation, they can certainly take into account riparian concerns. And under the Fish Protection Act, if a stream has been designated as a sensitive stream, then they can be directed to consider whether water flows are adequate. As you know, the Fisheries Act works, the Federal Fisheries Act works in tandem with water licensing in the sense that there is a requirement that there be adequate in-stream flows, or at least that is the ultimate sort of the ultimate result of certain sections of the Fisheries Act. But the involvement of federal fisheries staff in licensing decisions has been abating over the last decade and is becoming not present anymore in many parts of the province.
Okay, next question from John Waring. Can someone clarify the apparent discrepancy between the concept of use it or lose it and licenses are held in perpetuity? In perpetuity suggests there is no way to lose your license. When does use it or lose it kick in? Any examples where major water users have lost their licenses?
Well, I'll give you some U.S. water law examples. Yes, there have been licenses because under state law of both states, in Oregon and California, the ownership of the water is by the government, by the state. And what you get as a water right is a beneficial use right, what they call usufructuary right in Old English legal jargon. It's a right to use, but only for certain designated purposes in certain amounts and no more. If you are not able to use that beneficial, that water for that beneficial use, you can lose it, and that has happened. Unfortunately, what we've got is an over-appropriated system because so much water was given away. In California, for instance, about 3.5 times more water rights exist than the total rainfall in the state. In Oregon, it's not so bad as that, but it's still badly over-appropriated in many places. So the real question is, what is the public trust doctrine? What is the state obligation to maintain these flows, and to what degree can it cut back on those flows, cut back on those water rights in serving a greater public good? That's an area of law that's under much debate.
Yeah, the only thing I'll add is that when we use the term in perpetuity, we're meaning time. It's not time limited. So it's not a right that is good against anything. It's regulated in certain ways. So this usufructuary right continues on forever. There is no time limit as long as you do certain things. You pay for your water use, you use it, and you use it in the way that is specified in your license. So this is a very good point, because this is what I'm talking about, the opportunity or the significant regulatory space that we have to add additional regulations on the way in which we use licenses that could get at some adaptation or some environmental concerns. So rather than simply saying we don't have enough water in the system, we have to take water back from people who have it under license. What are some other types of regulation under the Act and the water regulation, like use it or lose it, or you have to use it for a particular purpose, or you can only use it at certain times of year, or you can only use it under certain environmental conditions? What are those? What is the package of those that would regulate the use of water licenses for environmental benefits and for the long-term sustainability of regions or communities?
Deb, let me feed you a quick question, which I think is an underlying concern. Does Canadian law recognize the famous public trust doctrine for water use?
It does not yet. There are several cases in the works, but we only have a very small statement from the Supreme Court of Canada about that there is a possibility that the public trust doctrine could exist in Canada, but that wasn't even in the water context. So there are lots of lawyers beavering away right now trying to find that
Oddly
case.
enough, it is not recognized in Oregon, but is recognized in California. So California has some potential right to cut back on water rights if failing to do so would violate the public trust doctrine, which essentially is that the public owns the water and it has to be managed for the public good. That's in debate, and we're actually in litigation over just how extensive that power is right now. But my view is if it isn't in statute, it's very, very difficult to enforce in the courts through common law.
Okay, following up on that question, in just a minute, Polis has a couple sort of legal issues brief and also previously hosted a webinar on the topic of the public trust doctrine, so I'll throw those links up there shortly. Before we go to the next question, regarding the previous question, which came from the Manitoba Conservation and Water Stewardship Group, John Waring weighed in on some of what Deborah was saying that no rivers or streams have been added to the BC Fish Protection Act sensitive stream list in over a decade. Next question is from Rick Simpson, asking to please comment about dam decommissioning process. He's heard lots about it, but is that proceeding in reality?
Well, let me take a crack at that. In the United States, for instance, there are roughly 70,000 licensed dams. Of those, only about 3% generate power. Of those, several thousand are safety hazards and have been condemned. Many of those are being taken down. 70,000, by the way, is one dam built for every day since the signing of our Declaration of Independence in 1776, plus a few left over. Many of those dams are scheduled for decommissioning and should be decommissioned before they become major safety hazards. Dams will come down one way or the other. Either they will be engineered to be removed, or nature will take them out in a catastrophic failure. Eventually they silt up, they become major hazards. Concrete itself has an engineered lifespan. The concrete starts to deteriorate, and you've got major problems. And several dams are in that situation. Last year there were some 70 dams removed in the United States. This upcoming year there'll be several more, and the Klamath are 4 major dams, but only 4 of many that are likely to be removed in the next 2 years.
Okay. Let me pull up my questions here. From Alan Thompson, what part of the negotiated plan between all signatories a requirement to drop all legal action between members? So was part of the negotiated plan between all signatories a requirement to drop all legal action between members?
Yes and no. What we did is we created an alternative dispute resolution process to try to get at those disputes before they ripened into lawsuits. There was also some existing litigation which we just continued until those were resolved, and they all have been pretty much resolved. Simply because there were non-parties involved, and if we had withdrawn, they would have gone on anyway. But so far, there hasn't been any new litigation in the basin for many years, and the dispute resolution process seems to be working.
So a couple comments here from MOE Victoria. I'll start with the second comment, which was in response to previous discussion, saying that in BC, in-stream flow has and will continue to be a consideration for adjudicating an application. Applications may be refused or licenses granted with terms or conditions considered advisable. And the question, also from MOE Victoria, is does the agreement cap or place a moratorium on any further development within the basin? If no, how are future development water needs addressed?
Very important. Yes, it does cap development of groundwater. It basically caps it at year 2000 levels, so we can't take a lot more groundwater than is there, was acceptably taken through permits in that year. It also imposes at least a moratorium on issuing new water rights until those are reconsidered in light of the needs of the environment and the tribes. In addition, the tribal adjudication has now awarded the tribe their senior water right. That was upheld by federal court. The extent of it is very large, and that alone will limit water development. In terms of housing and other development, it's a highly rural area. There's not a lot of development potential there. It's mostly farmlands. And there is no requirement that housing development have a guaranteed water supply, but as a practical matter, you can't get money to build if you don't.
Glenn, is there any move by the Klamath Water Users Association, so the Irrigator Association, to go to more efficient methods of irrigation, for example? So in Alberta and on the prairies, the large water license holders are the irrigation districts, and they're putting a lot of money into piping, for example. So they're creating piping all through their what used to be simply open ditches, knowing that the evapotranspiration, what they're losing in the summer, is significant.
Right. The irrigation system up there is 19th century technology, including open, unlined ditches, very wasteful of water. Water has become much more precious than it was 150 years ago. So yes, one key element is the irrigators are going to have to learn to live with at least 100,000 acre-feet less water each season. However, in return for that, we're providing them some resources to make better efficient use of it, changed the ditch system to lined, covered ditches when possible, sprinkler irrigation rather than flood irrigation. And the innovative part of it is we're relieving it to the irrigators themselves, who are very creative people, to try to figure out how best to do it by getting them the resources for implementing that plan. In the end, they have to live with less water.
So the next question or comment, coming back to the discussion about the public trust doctrine, and I have thrown up a few Polis links in the web links window there, from Serge Villeneuve. My understanding is that a Quebec law, and I'll try to read it, I apologize for my French, the loi affirmant le caractère collectif des ressources en eau, states that water is a common resource or public trust. I don't know, Deb or...
Yeah. So there's a very interesting, relatively new law in Quebec that talks about how it talks very much in public trust terms. So a couple of students in my water law course looked at that last fall and compared it with sort of the principles of what we would say, what are the principles of public trust doctrine, and looked at the Quebec law specifically and found that, yes, in fact, it did meet sort of the test of a recognition at a provincial level of what the public trust is, where they found it challenging to sort of affirmatively declare that we in fact have the public trust in Canada, or a public trust recognized in Canada, is that there's been virtually no adjudication on it from a court perspective. So in terms of its interpretation, it doesn't yet seem to be having an impact on decisions that are being made, and it's more sort of general statements of the law. So they held off on sort of declaring, yes, in fact, we do. Here's a great example in Canada. But it is an interesting example to watch over time as it becomes more discussed, and to see whether, in fact, like, for example, sort of the Environmental Bill of Rights in Ontario or the Yukon, whether, in fact, it has any impact at all on the way in which we manage water.
Okay, I'm going to just skip the next question for a minute and get to John Waring's comment, which gets back to the licensing discussion. He's saying that in-stream flow may be a consideration in review of water license applications in BC. Enforcing minimum flow conditions once licenses have been issued seems to be a problem I'm not sure, with some private hydropower operations. I don't know if either of you have anything to add there.
Well, I think the experience is that across BC, all decision makers say that they consider in-stream flows. There is no standard by which they consider them at this point in time. So, certainly the conversation through Water Act modernization and it being the primary priority, or the number one priority, to ensure water for the environment or water for ecosystems, is to either decide on a process by which that is determined, or to set some standards. So we certainly have mean annual discharge requirements that are considered explicitly here on the east coast of Vancouver Island, but how exactly those in-stream flows are considered in other regions, other provinces, is not entirely clear or transparent at this point in time.
Okay, question from Rick Simpson for Glen. From your experiences with the Klamath process, what are the major lessons learned that you could pass along? This area, and he's based in the Okanagan Basin watersheds, is also a water-limited, semi-arid biogeoclimatic zone. I'm anxious to see us learn from the pain and successes of others and to avoid many of the issues and expensive problems that you've described.
Well, that's a big question. I think one of the things we learned is people will not cooperate until they have to. Every other opportunity to get their own way for every stakeholder had to be exhausted before people actually sat down. And the rotating crisis nature, first one sector, then another sector, then maybe both simultaneously, of drought, fishery failure, collapses of fisheries, major fish kills in the river, all of that combined really forced people to say, this isn't working. But people tried for years to go to Congress and change the laws. That failed. They tried for years to go to court and change the court rulings. That failed. It wasn't really until everything failed that the mainline folks in the middle of this process were able to craft a solution. And some people still don't accept it. Some people still want it the way it used to be, where they got everything they wanted and nobody got anything else. That just isn't going to happen. And the more you develop a sort of a radical middle, you can pull in those people bit by bit, but it's a tough slog. One of the most important things is that if you've got a depleted groundwater system, that's going to affect everybody. So everybody's ox can get gored, and that is a common ground for mutual panic, which can result in some serious efforts to look at reality. But it's a hard row. There's no doubt about it. And it wasn't really until the litigation and court-ordered negotiations commenced under the judge's thumb, basically, that people were forced to sit down and they started saying, well, we ought to actually talk about something. We're not winning in court. Nobody's winning anything. Maybe we should come up with something different. And it's not until the status quo is so painful for a lot of people that negotiation looks good and that negotiation can actually get them something they would never get any other way, that people began to cooperate for real.
Okay, question from Rob DeLoe, again for Glen. Who gets the water saved by farmers who line their ditches, etc.? Does the ag sector get to use the saved water, or are there provisions to use for environmental and other purposes?
Well, again, it depends on the state law. In Oregon, that water can go for environmental purposes because there is an in-stream water right law. In California, it's much more difficult to do that. But under the agreement, which would prevail among those parties who are signatories, it's the cap that's important, not what is done with the water savings. It's if there's water savings, they can make better use of it, provided they don't go under that over that cap. The other issue is that the irrigation system is limited. There's no way to ship that water anywhere. Most of the viable land has already been used. It's not going to expand. It is at its full extent. So, expanded water demand is very unlikely, and it would be capped under the agreement. So we're leaving it really to the irrigators to figure out how best to use the water they get, but making sure that that water is not exceeded so that the remainder of the water goes downstream for the river and the fisheries.
And from Darwin Horning, Glen, can you talk a little about the water-energy nexus, increasing demand for energy, reduced water availability, and the decommission of dams?
Again, another big topic. It's all intermingled in the Klamath Basin. That's not unlike a lot of river systems in the Pacific West Coast. Again, the dams were not an issue about water quantity, since every gallon that goes into the reservoir has to ultimately go through. They're not storage dams at all, so it's a run-of-the-river situation. But one of the reasons the dams were no longer economically viable for the company is that there were all these competing demands for that same water. They would, for instance, only get water when the irrigation system wasn't running sometimes. Or they wouldn't get enough water at the right time for their energy demands. So it was becoming less and less viable. Altogether, it only generates about half of the potential energy that it's rated for, simply because a lot of times the water isn't there, particularly in the summer. Summer is maximum energy demand, air conditioning and things like that, but minimum water flow to create that energy. So ultimately, that plus the fact that the dams were creating water quality problems, immense water quality problems, made them less and less viable. And when a deal was worked out for the company to get out gracefully, they took it.
Another question from Tyler Palov. Can tribes or any users choose to use their water right by choosing to have water left in-stream and protected downstream?
That's interesting. The tribes have multiple rights, and it depends on the tribe. The tribes that have fishery rights also have a guaranteed right of sufficient water retained in the river to provide for that fishery. So that's how they get into water rights. Fisheries rights become water rights, and courts have upheld that. So a lot of what the tribes want is they want sufficient water for the support of their salmon fisheries and their way of life, as well as their ceremonial uses of the river, to be left in stream. And so that, and if it's left in stream, it benefits everyone, including commercial fishermen lower in the river.
Okay, and last question, I think. We have about 5 minutes on the clock, so if anybody else has any questions that they want to ask, please do so now. If no more come in, this last comment or question from John Waring, one of the biggest roadblocks in Canada for doing this kind of water use planning is finding funding to keep such multi-stakeholder processes going. Deb or Glenn, I don't know if you have any thoughts on that.
Oh, I'm delighted to jump in on this one. This really goes to the heart of the work that the Polis Project does, and I think it speaks to the need to blow open our very siloed approach to the way in which we do regional planning. And when I say regional planning, I mean land and water collectively. So if we have we have lots of money going into multi-stakeholder processes all the time. They just don't tie together land and water decision making. So if I think of the amount of money that the City of Victoria just put into redoing their official community plan, really excellent process, highly collaborative, very engaged. If water was tied into that, and then also tied into our regional water management system for our drinking water, there's lots of money there paid for through user fees, through a stormwater utility, through drinking water, what we pay for our drinking water, through what we on our property taxes that goes through planning, as well as provincial government funding for planning, for example, land and resource management plans on the Crown landscape. So if there was some coordination amongst those things, whereby you could get the benefits of pulling them all together, it would certainly be complex, but no more complex than we already do, for example, for an official community plan that considers, for example, the City of Victoria is an urban municipality. It's entirely built out, yet we consider food systems planning. That's a big part of the new official community plan. We consider, climate change adaptation, all of these things that arguably aren't within the jurisdiction or the specific purview of the day-to-day operations of the municipality, but because they are of concern to the citizenry and the people who pay taxes, they are paid attention to. So I think there are tons of opportunities in creative ways to funnel money into these processes, but they shouldn't be standalone. They should be integrated with the other entitlements, to use the environment process that we have ongoing. We're also very lucky in British Columbia to have a number of foundations, like the Real Estate Foundation, that would, I argue, they would put a lot of money into these kind of ongoing planning processes.
Yeah, let me jump in quickly. John, you hit a big problem, and that is you create a system, you've got to fund it. You have to fund monitoring, you have to fund infrastructure upgrades, you have to fund conservation measures. And all too often what we wind up doing is these 50-year plans based on one-year federal budgets. Is finding alternative off-budget non-federal sources is a major issue. In the water rights issue, for instance, we have in California, we're moving over to a user-based fee system for water masters. Water masters are the people who decide when to cut you off because you've exceeded your water right. That's very important for the people downriver. The problem with that is when the government isn't paying for it, then the people who are water masters are beholden to the constituents that they're regulating. So you have plus and minuses each way, but we have to figure out throughout our whole system how to pay for good science if we want good science, good management if we want good management, and infrastructure repair and upgrades if we want to keep things running.
Okay, well, with that, I'm going to hide these so that you can actually see my slides. I want to thank everybody for being here. That was a really wonderful discussion. As I said at the beginning, our next webinar will be happening in June. I don't have the exact date yet, but I'll certainly let you all know when we have that nailed down. And it's going to be on the topic of rights of waterways with Linda Sheehan, who's the Executive Director of the Earth Law Center in Southern California. There will be another speaker as well. We're just waiting to confirm that. And again, we record all of our webinars, so if ever you want to revisit any of these topics, you can head to our YouTube channel, and they're all archived there. So that's it for me. Thank you to everybody. Deb and Glenn, do you have any final words?
No, just thanks very much, everyone, and carry on the conversation. We're going to see a lot of change in the next decade with the way in which we manage water, so it's an exciting time.
Yeah, well, change is inevitable. I always caution people not to be consistent. Consistent is defined as being as stupid this year as you were last year. We have to change in light of the fact that the environment is changing around us. We have to be flexible, and we have to adapt. Adaptive management is, for people in the fishing industry, very simple. You look ahead and make sure you don't hit any rocks.
Great. Thank you both so much. And to everybody on the line, have a really great rest of the day. And hopefully we'll see you in June.